Hi everyone, I'm Vishal. I'm the legal counsel at Hashed Emergent, which is Hashed's emerging markets and India focused fund. I'll be talking about um, two things, the legal situation in India and a little bit more about the concept of harmonization generally. Yeah, so these are the four broad parts of my presentation. India's market landscape, India's regulatory landscape, talk about a bit about the concept of harmonization and then how harmonization interacts with decentralization. Okay, so this is what the Indian market landscape looks like. There's been quite a lot of funding and many startups, but broadly what I want to show you here is that most of these players are very, very centralized. In the beginning, there were a bunch of exchanges, and some of those exchanges are still there. They've done large funding rounds. They're weathering the regulatory storm. There is one large L2 from India. A lot of these are sort of adjacent. They're service providers, SDK providers, custody solutions providers. Cricket is very popular in India, so people tend to put cricketers on NFTs and sell that as well. This is what the Indian market looks like. There's not much decentralization. There's, I would say, less DeFi and more services based kind of businesses. This I think when you're talking about law, it's also very important to talk about policy concerns first. I would say most of India's policy concerns around Web3 comes from what we call dollarization, which means that we don't want the entire economy to be denominated in US dollars. We want it to be denominated in rupees. And to that end, what India does is we have strict FX laws. The rupee is not convertible on the capital account. And this is one of the pain points of crypto for the Indian government. They think that you can bypass the strict FX laws using crypto. Other issues which have come out from recent statements by the Indian regulators are AML/CTF, which is obviously important for everyone. Macro and financial risk concerns, also very significant for the Indian government because it's an emerging market. And I think the thing which has received least attention until now is investor and consumer protection. The Indian government usually waits until there's a scam and people get their fingers burnt, and then they step in and regulate. This is the Indian regulatory landscape. At the bottom, there is a Supreme Court ruling that overturned a ban on banks that injuncted the banks from ever dealing with any crypto services whatsoever. This ruling is very important because it ensures that Indian regulators will never try to, slap a very harsh ban on any area of the market. I think the only actual law in India right now is an AML/CTF law. So it applies to everyone who does business with Indians. And though I don't really know how hard it is to comply with it. People who are in the ops space tell me that it is indeed very hard to comply with. I think I would say, okay, there are only two laws to actually deal with crypto in India. One is the AML/CTF law, and the other is a tax. The tax is notable because it treats your profits from crypto in the same way that it treats your profits from gambling. So they basically look at it as a very bad thing. If you make money from it, they'll try to take most of your money away. I think so these are the actual laws, the first three layers. The next layers are softer things which you just understand from looking at the market. No one really knows whether you can operate your business. There's a lot of regulatory murk. The central bank, which is a very powerful institution, does not like crypto at all. But the government seems to like blockchain tech and wants to foster it. I think the last trend that we see as lawyers is that many of the projects we interact with, they flip their companies offshore. And if they launch tokens at all, it's outside India, not inside India. And you can't launch a token inside India and raise financing because it would be regarded as a security. So I think just to lay out all of this again, there's only AML and CTF laws. There are no other specific laws tailored to crypto. The financial services and securities laws have never been enforced. So there's no concept of trying to retrofit them back onto activity in the crypto market. VASPs do try to self-regulate, and There have been enforcements against them, but only by FX and AML regulators. Most banks in India will not really touch a crypto company. I think one encouraging thing that we see is that there's been a shift in narrative. Before, the government really didn't like crypto. Now they seem to like it, and they're trying to think about how to introduce a CBDC. The background of laws that generally regulate life and commerce in India, there's no clarity on how they will apply to the crypto market. Lastly, I think one thing that I want to note is that there's a very powerful internet regulator, and this internet regulator is connected to the other regulators. So if the financial regulator sees that you're running a DeFi app and it thinks that it's a financial service, it should be regulated, the financial services regulator can go to the internet regulator and say, shut that app down. It can go to Google Store and Play Store and say, get this app off your market. So that I think is an emerging concern. Okay, I think I've covered basically the law in India. Now I want to talk a little bit about harmonization, because I hear the word bandied about a lot. And I thought it would be a good place to start would be to look at what kind of harmonizations have happened in the past in other kinds of laws. So Thomas brought up the EU's passport regime. I think it's a great example of harmonization of laws in one area. You have the New York Treaty on Arbitration Awards. So if I win an arbitration in Singapore, I can bring the arbitration award to India and have it enforced by an Indian court. So that's also a harmonization. Then you have the Paris Convention on Parity, which means that if I file for a patent in one country, the filing of the patent and the principle of the patent will be respected in all other treaty parties. Then all the practicing lawyers here will know about the Hague Convention on apostilles. So if you get a document notarized in one country, that notarization is respected in other countries. All of these are, to me, examples of situations where nation states collaborated, entered into a treaty, and harmonized laws that were not exactly in sync, so that commerce around the world and globalization could happen a bit more smoothly. You also see examples of forced harmonization. One example is the FATF's gray list. So if your AML protections are not strong enough, you go on a gray list, then most sophisticated entities will refuse to do business with you. Another example is IMF bailout packages, which have happened in a lot of countries. If you have a balance of payments crisis, the IMF will step in and say, we'll give you money and rescue you, but you need to loosen up your FX laws so that foreign capital can flow in. This is how harmonization has been happening in other areas for many years now. What can we take away from this? There is an interplay between harmonization, sovereignty, and arbitrage. And I think it's important to understand the incentives of countries when they try to sit and talk about laws and talk about harmonization. Harmonization means that you're letting someone else tell you how to draft your laws, and that is giving up a bit of your sovereignty to someone else. So in my experience, countries do not want to cooperate with other countries unless there's a very, very good reason to do so. And usually when countries' laws diverge, it's because they want to be more protectionist about players in their market, or because they want to regulate very, very lightly and create an arbitrage. For example, the Bahamas may have had a very, very, very light exchange regulation law because they wanted to arbitrage and attract players there. Similarly, you have offshore tax havens which have zero tax. That's an arbitrage which they are achieving because they do not want to harmonize and they want to use their sovereignty to drive a different legal and commercial outcome. I'd now like to go to the G20's present approach. The G20 is discussing crypto extensively. They're the most powerful nations in the world, and what they say will, I think, generally have a big impact on crypto regulation in the next 2 or 3 years. So what the G20 seems to be saying is that countries inside the G20 should agree on a minimum kind of regulation, and they are free to regulate more, but not free to regulate less. And you can see that they've specifically said that they do not want to have regulatory arbitrages, which means that they are afraid of players setting up in less regulated countries and effectively getting around their local laws. I think that this will lead to a coordinated race to the bottom, where most countries will adopt strict laws. And it's very different from a bunch of nations getting together and saying, none of us will make laws that are more stringent than this. They're saying all of us will make laws that are at least as stringent as this. And I think that leads to very different incentives and a very different outcome. I think to round off this discussion, we just want to talk about what we think, one of the ways in which we think harmonization should be done. We feel that while there are so many things on the table to talk about, securities laws, financial services laws, AML, CTF, the most important first principle to get right is to understand whether a project is centralized or decentralized. If a project is decentralized, we believe that as a first principles, nations should harmonize their approach and regulate it less or differently, or what you would say is a tech-informed manner. Some of the themes playing out here are that obviously centralized assets, actors, they're most probably going to attract the most capital. They take custody. They are definitely, high-risk actors, and we've seen that play out in the market before. It is possible to regulate centralized actors, and governments should cooperate to do it. When you come to decentralized actors, I think there's growing recognition that if you're decentralized, you should not be subject to the same laws as centralized actors. There's a strong reason for this, which is that there's less custody risk. There's hopefully in the future more decentralized governance of these protocols. And if something's truly decentralized, it'll be difficult for even nations cooperating together to regulate it. I think another very important thing is that we should try and draft our laws in a way that incents decentralization and not in a way which discourages decentralization. And if nations could get together and harmonize around this principle, I think that would be very helpful and encouraging. To conclude, I'd like to talk a little bit about decentralization itself and why it merits a different approach. So when projects initially begin, it's like a closely held partnership. They try to make decisions in a nimble and fast way. And they usually set up as companies or partnerships, and they're regulated by the countries that they're set up in. Then as decentralization progresses, you have stages where there are a few powerful actors who control the company. And they sometimes engage in what we call decentralization theater, which means that a project pretends to be decentralized, but it's not really decentralized. And a lot of protocols do manage to go to the next stage, which is a democratic state. This is somewhat similar to a big listed company that has distributed shareholding. Decision making is less robust, and I think the key thing that we look for in such protocols is that there's a wide spread of token holders. The fourth stage, and this is, I think, the stage where you can say that no one really controls this beast. So we need to rethink about the kind of regulation that it's subject to. In our experience, very few protocols have reached this stage. And it's usually characterized by what we call the Bahamas test, which means that if the entire team one day decided to get up and go live in the Bahamas, the project would just keep running as though nothing happened. Yeah, so I think just to sum it up, we feel that if, when projects should be incentivized to get to stage 3 and stage 4, and when they do, they should be regulated differently. And this would be a great principle for nations to harmonize about. Okay. Thank you so much.